morning. We wanted to welcome you guys to our series of webinars that we're offering for employers around the state. This is our second one in this year-long offering. Please feel free to share these invites with anyone you know or have them contact us so that we can get them on our list. We want to get this out to everybody across the state. So yeah, feel free to share. Our next webinar, just to have on your calendars, will be May 31st, and it will be on wage and hour. And so that's usually a pretty popular one for employers, being able to ask those questions of breaks and lunches and pay and overtime. So it's always a great workshop. So please make sure you're on our list for next time as well. Today, as far as the webinar, it will be recorded and we will have it out on YouTube. But since we had you guys register to start today, we have your email addresses, and we will, after this presentation, send out an email to you with today's slide deck and with the link to the YouTube. So if you wanted to watch it again or send it to somebody who wasn't able to make it today, we'll have that information available after the presentation. So for today, I'd like to turn the time over to Ben Earwicker. He is the administrator for the Idaho Human Rights Commission. So Ben, thank you for attending this and helping us out today, educate employers.
Yeah, thank you, Candy, and thanks everyone for joining us. It looks like we've got about 80 participants today, so it's a great day for a lot of employers around the state, and so thank you for joining us. I'm going to share my screen and my PowerPoint. It looks like chat is disabled, but the question and answer is open. So as we go through this today, if you have questions that come up or things that you think of in real time, go ahead and put them in the question and answer, and I'll try to answer those as we go along. So I appreciate you being here today. Typically, when I present to employers, we talk about the Human Rights Commission and what we do and the ways that we serve both businesses and individuals, employees. Today, we're going to talk specifically about internal investigations and working through the IHRC, the Human Rights Commission process. So for some of you, you're familiar with the Human Rights Commission. Maybe you've been to one of my presentations before. So some of this may be a bit of a review, but I want to focus on specifically how to engage in an internal investigation and then how to respond to a formal charge of discrimination if you have one from a current or former employee. So as we work through this today, I'm going to describe, to begin with, the scope of an IHRC or Human Rights Commission investigation and the nature of the work that we do around the state. And so we are a state agency. We don't represent parties. We are neutral. We're a third-party administrative law agency. And so we'll go through and touch on the various aspects of the work of the commission. Secondly, I want to use this time today as a training, and maybe you weren't expecting that, maybe you were just hoping to hear some about the Human Rights Commission, but I want you to think about this as a hands-on, engaged learning session where we can not only talk about best practices, what to do, what not to do, but I want to give you some tools that you can use when conducting internal investigations of discrimination complaints or other types of complaints that you may receive from employees. And so hopefully by the end of today, you'll have some added skills and perhaps some new ways to go about conducting internal investigations. So by the end of today, I want you to understand the entire investigative process from start to finish, and also learn about some of the resources that we provide from the Human Rights Commission for employers specifically. If you've interacted with us before, it's most likely because you received a formal charge of discrimination or retaliation from an employee, either current, former, or at the hiring stage. But we offer a number of other services to businesses, trainings, free services that we will provide in person or remotely via Zoom or via other platforms. We're going to talk through, like I mentioned, best practices, but I want you to be able to articulate those back to staff in your businesses. Whether you're an HR professional working with staff or a business owner or a manager or supervisor, the strategies and tips that I share with you today will be very useful in responding to complaints of any kind. And then finally, if things do escalate to the point of a formal charge of discrimination, I want you to feel confident in responding to that. knowing the process and not feeling intimidated by a formal legal charge. So the Human Rights Commission was established in 1969 by the Idaho legislature. We are a neutral administrative law agency. So when individuals come to us, oftentimes they think of us as the ACLU or a private law firm or some other nonprofit that would advocate for their interests. We're actually a state agency, we're neutral, and we adjudicate disputes between parties. And so in that sense, we're more like the courts than we are a nonprofit. So we're not an advocacy organization. We're not representing the interests or perspective of one party or the other. Now, businesses will often say to us, yeah, but you prepare the forms and you serve us, and it looks like you're representing the individuals. We do offer certain services to both parties, including things like mediation, service of process. We do assist in the preparation of the initial forms that are filed and then served. In part, that's because when we have pro se litigants, that's litigants or complainants that file on their own behalf, oftentimes the complaints, if they're handwritten or even typed, they may be meandering, they're difficult to understand, and they may include a lot of irrelevant and non-jurisdictional issues. So one of the things that we do through our intake process is refine and try to narrow down the scope of the complaint to only those things that are jurisdictional to the Human Rights Commission, and specifically anti-discrimination laws, both state and federal. So when someone comes to us, they may be complaining of a number of different things, some of which would be under the jurisdiction of the workers' compensation and the Industrial Commission. Perhaps it's a safety complaint for OSHA under the federal guidelines and statutes. Maybe it's an FMLA leave request issue or a wage and hour issue with the Department of Labor. So all of those things we'll receive requests for, and then we refer back to you as the business first and foremost, and then secondly to other agencies that may have jurisdiction or something to do with those issues. The issues and the scope of work that we do has exclusively to do with anti-discrimination and anti-retaliation laws in the state. And I'll list the laws that we enforce and work with through our partnership with the federal EEOC to prevent also violation of federal laws. So these three areas, prevention, protection, and resolution, this captures the scope of the work of the Human Rights Commission. The largest area of our work is prevention, and that is the legal, law enforcement, and the administrative review that we conduct in each investigative case. That, I would say, is about 75 to 80% of our work. We receive complaints, we file them, we serve them on the party against whom the complaint is brought. 90+% of those are in the employment context, and about 10% are housing, education, or public accommodation. So depending on the nature of your business, if you have customer-focused services, if you are engaged in customer service of any kind, you may also experience complaints of public accommodation in addition to employment complaints. So that prevention piece is largely what we exist to do. But I will say, even though that can be kind of intimidating for a business when you receive filings of discrimination, we are an administrative remedy that has to be exhausted before a party can go and file in court. So your employees, your customers can't just go to district court or federal court and file a complaint of discrimination. They first have to come to the Human Rights Commission and exhaust our process. So while our process is still a legal process, it can be intimidating, it can be frustrating, it can be long, it's still better than going straight to court and having all of the legal expenses and all of the headaches of litigation. And the majority of our cases are resolved at some stage along the way, and we'll talk about resolution in a minute. But mediation is one way that we resolve cases through settlements, through negotiated agreements between the parties. If we don't mediate a case, we'll conduct a complete investigation and issue determinations and findings. And depending on the outcome there, in many cases, a party will elect to not continue on to court. In some cases, a party will proceed on to court, and that is in some cases inevitable, where you have a party who is insisting on pursuing a legal claim in court. But I would say those are a small minority of cases that we review and a small minority of cases that are brought to the courts. The second thing, I'm sorry, that really is more of the area of protection, the middle category. The prevention category, I mentioned before that we provide free trainings to businesses. We offer free sexual harassment prevention trainings, respectful workplace, disability accommodations, diversity, equity, and inclusion, and a whole range of other customizable trainings for businesses large and small. We've done trainings on annual respectful workplace for businesses as small as 4 or 5 employees. We've also done trainings for some of the largest employers in the state. A few weeks ago, I was up in North Idaho and conducted trainings for the largest employer in North Idaho. We did, on their request, we kicked off their diversity, equity, and inclusion trainings that they're rolling out system-wide. And so I trained 2 groups of about 75 leaders, their executive leadership team, supervisors and managers. And then from there, they're rolling out a comprehensive plan throughout their business. So we can do a lot of customized trainings. We offer that as a free service. We don't charge anything for our costs of getting there for travel, transportation, or the provision of the service. If you go to private companies, you will know that those trainings can cost upwards of $5,000 or more, depending on the package that you purchase. And so that's a valuable service for you as businesses in the state. But if you go to our website, it's humanrights.idaho.gov. And then if you click on the links in there, you can find my contact information and you can send that directly to me. We do travel around the state. We're located in Boise, but we provide services in person anywhere in the state. I'm frequently up in North Idaho, Eastern Idaho, and the Magic Valley. So it's pretty easy to coordinate those in-person trainings if you would prefer. Those tend to be a little more engaging and interactive. I think they tend to be more effective. I think it depends on the employees that you have. If you have supervisors that are busy, maybe an online webinar is more effective. But at any rate, reach out to me through the website. The final area, the resolution area of our work, is the mediation and conciliation service that we provide free of charge to parties of a complaint. So once a charge is filed and served, the business is asked to respond to a charge within 30 days with a written response. At that point, we offer both parties the option of free confidential mediation through our investigative process by a trained mediator. I provide all the bilingual mediations in Spanish, and my 2 senior investigators are trained and provide all of the rest of the mediations that we see. We have a very high success rate. When parties agree to mediate and come to the table and negotiate a settlement, we have about a 75 to 80% success rate at that stage. Now, when I say settlement, you might immediately think monetary settlement. Now, that sometimes is a part of the negotiated settlement, particularly when an employee has lost certain benefits or pay. Perhaps they've been demoted, perhaps they've been fired. And so there may be a financial component to that. But in many cases, the negotiated settlement deals with things like a reasonable accommodation and finding ways to resolve an outstanding concern or issue with a reasonable accommodation. It may involve transfer to a new position. It may involve dealing with ongoing harassment that hasn't been addressed directly. So resolution really is something that I'm proud of that we do as a free service to parties. It's not something that every party takes advantage of. Obviously, in a case, we always have 2 parties to a complaint. And so one or the other may not be interested in sitting down at the table and having those discussions. And so it's not guaranteed that you can engage in mediation, but it is a service that we offer. So I have another question here. Do we offer any services for orientation type trainings for new employees? We do offer I would say, a comprehensive introductory training that includes respectful workplace, harassment prevention, and employee and employer best practices. And those have to do with specifically the employment laws that we enforce and work with. What that does not include would be FMLA and FMLA leave, workers' compensation, and other benefits. So anything outside of the scope of the laws that we enforce would not be included in that. But we do new employee orientation type trainings related to anti-discrimination and anti-retaliation. So I've already mentioned, and I won't spend a lot of time on this slide, even though there's a lot of information here. I mentioned that our process is required before a filing in district court. We also coordinate our efforts with the EEOC, the Equal Employment Opportunity Commission, for federal notices of right to sue. Now, what that means is that at the end of our process, or throughout our investigation, the party that has filed the claim can request a notice of right to sue so that they can proceed to district or federal court to sue. Now, the EEOC and the federal policy is that if they cannot complete an investigation within 180 days, so 6 months, they will automatically issue the notice of right to sue and allow the party to proceed on to court. Under Idaho state law, that time frame is actually 1 year. So if we cannot complete an investigation within 1 year, I have to automatically release that case upon request and issue the notice of right to sue. Because of the difference in federal and state law, I have aligned the two processes so that if we receive a request at 6 months or later, I will also release that notice of right to sue. And anytime prior to a year, that's at my discretion. And so I've decided to align both the state and the federal practice. So if someone files a suit with the commissions and we have an open investigation, but they really want to proceed to litigation, I generally will never release the notice prior to 6 months. And if we get a request at 3 or 4 months, we'll do everything we can to resolve that complaint and complete that by the 6-month mark so that we don't have to cut short our investigation. Timeframes. We always get questions from businesses. There may be a disgruntled employee who left 2 or 3 years ago that comes back and threatens to sue. If that's the case, that claim is time barred under both state and federal law. A federal claim has to be filed with one of the commissions prior to 300 days since the last date of harm. Under the state law, a claim has to be filed within 365 days or 1 year from the last date of harm. Now, if someone was fired, let's say a year ago today, that is technically the last date of harm. Now, they may argue that they have ongoing harm or ongoing injury or damages after the date of firing, but for the purposes of a discrimination claim, we consider the last date of employment to be the last date of harm. Now, the one exception to that I've seen over the years, we have seen claims where an individual is fired, but then the employer proactively reaches out to prospective employers or future employers and actively provides negative reviews or disparaging remarks. So that is a case where maybe the last date of harm may be after the date of termination, but that's very uncommon and very rare and kind of a very narrow exception. Now, there's another category of claims, and those are considered ongoing complaints. So someone who is still employed that's alleging some kind of protected activity harassment or protected category harassment, sexual harassment, national origin harassment, disability harassment, and they allege that that's ongoing. And so the statutory time frame continues to move forward in time. So let me share just a few stats, and I won't spend a lot of time on these numbers, but there are a few interesting areas that I wanted to highlight. So in an average year, we receive between 300 and 400 complaints of discrimination. My staff of 10 investigators and support staff will process and complete an equal amount of investigations each year. Of those, over 70% every year are no probable cause findings. And what that means is that we don't find that there was any illegal discrimination that occurred. Now, that doesn't mean that something wasn't problematic, unethical, that nothing happened. We're not saying that nothing happened. We're just simply saying that based on the facts, based on our review administratively of the relevant employment laws, there was nothing that occurred that was a violation of state or federal law. The second category, mediations, settlements, and successful conciliations, are just under 10%. And so of those cases that come to mediation, we have a high success rate, but only about 10% of cases actually go to mediation and are resolved in that way. Conciliation failures, now these are cases where we do find probable cause that discrimination occurred, and then we attempt to conciliate that. So that's like mediation. It's an effort at resolving the case after we've found that there's been a violation of law, but those are failed conciliations. They don't resolve. And in those cases, the party that receives the notice of right to sue is fairly likely to go on to district or federal court, because we have found in their favor. And so the facts are in their favor and they are likely to proceed on to court. Finally, the last category, there are about 15% of cases that are non-jurisdictional, where we issue a notice of right to sue without findings. These are cases where an individual insists on filing, demands the right to file before the commission, even though we may say you haven't established the prima facie showing, the initial showing of discrimination, or it's not jurisdictional under the relevant protected categories, but they insist on filing. So we bring it in, and then I will dismiss that administratively for lack of jurisdiction. The other case would be a claim is filed. The employee says, oh yeah, I don't know how many employees they have, but it's a lot. The employer comes back and says, look, we don't have more than 5 employees. In fact, we only have 3 employees. So there's no jurisdiction for us under these laws, either state or federal. So we'll do a check with the Department of Labor. We'll look at the number of employees in successive quarters. And if there aren't enough employees, then we'll dismiss that for lack of jurisdiction. The threshold is 5 or more employees for a state claim and 15 or more for a federal claim. And then under the Age Discrimination and Employment Act federally, there's a threshold of 20 employees. So if you're a small business and you have 7 or 8 employees in each successive quarter, then you would only be subject to state anti-discrimination law, but not federal. And that's really important. And so if you're served with a claim and a charge of discrimination, you always want to respond with the number of employees. Now, it's not full-time FTEs, it's number of employees that you have hired. So if you hire 20 part-time employees for 10 hours a week, those are counted as individual employees against those threshold numbers. And so if you have a question about that, if you're served a charge and you're not sure where you fall, you can always reach out and ask that question or include that in your response. Great, I've got another question here. Thanks, Francisco. Am I required to always translate and disseminate any correspondence, so employee handbooks, standalone policies, job descriptions into Spanish, if I have employees who only speak Spanish? So that's a great question, and it gets to issues of reasonable accommodation, which typically is only required for religious or disability accommodations. Now, it's always a best practice to provide communication in an employee's preferred language, but that can be overly burdensome if you have a 100-page policy manual to translate, or a large number of documents. So there's another factor to consider, which is reasonableness. Is it reasonable for you to do this? Is it an undue burden to do this? And so I would say that the best practice, and something that we do as a service provider, and it's a little different for a state agency, but our practice is to translate critical documents. So the primary documents that we provide, letters of notice of service, correspondence with the parties, we have all of those translated not only into Spanish, but any other language that is requested. And then for any other documents, we offer the parties optional translation or interpretation services as needed for effective communication. And so, for instance, at the Human Rights Commission, we have a language access plan, and we have a policy in place that regulates how we provide services in other languages, both written and oral. It's our practice, because it would be prohibitive to translate every document that we receive in a case where we have a monolingual, non-English speaking individual. So we wouldn't translate, for instance, a 50-page document that comes from a business to us as part of our investigation into another language. But we will offer to work with that individual for a live interpretive service through Language Link. We will do written translations upon request of certain documents. So my long rambling answer to that is I would have in place a policy. I would translate critical documents, safety manuals, those types of things that are essential for performing job duties. And then I would have in place a policy for how that person can access, or how employees that are non-English speaking or have preference to speak in another language, how they can access those documents in their preferred language. All right, the other statistical thing that I would mention here is that the total cases I mentioned are between 300 and 400, depending on the year. But these are some of the areas that we see most commonly. So the first is discharge, and by far the largest number of cases have to do with discharge. And so these are the issues that are raised, but not the specific protected bases. And so we'll talk about that in a minute. Protected bases are the protected categories under state and federal law: sex, national origin, color, race, religion, age, disability. And then retaliation on any of those bases. So retaliation we'll talk about in a little bit when we get into the investigative stage. But a lot of employees will come to you and say, well, I'm being retaliated against because I didn't meet my performance goals, and now my supervisor is being really hard on me more than anybody else, and it's because I didn't meet my goals. But not everybody meets their goals, and it's just not fair, and it's retaliatory. Well, in the broadest sense, that might be true. B follows A, and there's a causal link, right? Because I didn't do A, now I'm having to do B. So in the broadest definition of the word, that is retaliation, I guess, in one sense. But illegal retaliation is when someone experiences an adverse employment action because of participation in a protected activity. And that means that they have to complain about what they believe in good faith to be illegal discrimination, or they participate in a proceeding about that issue. So a proceeding before the Human Rights Commission, a complaint with HR internally, but at some level, there has to be a connection to one of those protected bases. And only then can that be considered connected to illegal retaliation. So I think that's important to know as employees come to you and complain of retaliation, to distinguish between what is potentially illegal retaliation and what is just a causal effect of maybe their own conduct or of interactions in the workplace that are not related to protected categories. Okay, going back to the last question, can anyone translate, or does the translator have to be certified? So that's a good question as well. Now, it depends on the industry. So under various laws in the healthcare industry, there are certain requirements for certified interpreters in the medical field. So if you are, one of the large hospitals in the state, you're going to have requirements to have certified interpreters that can work in the hospital setting. If you were the courts have the most stringent requirements for court certified interpreters. And in fact, in Idaho, they provide the only interpreter certification program that's recognized in the state. It's hard to say in routine, typical business practice that you have to have a certified interpreter or translator. Again, best practice is to get someone with qualifications and that has a background in that. And so if you use translation services, there are a number here in Idaho that provide interpretation and translation services. Always good to go with someone with experience and credentials and qualifications, but not a requirement under the anti-discrimination laws. Okay, next question. If a past employee is retaliating against the business, what is the business able to do to protect itself? Are we able to file a claim against the past employee? That's a great question. And that's the type of question that I would recommend you speak with an attorney about in terms of what are your legal rights for, say, a defamation claim, something like that. So there are different causes of action that you as a business may have, but that's something that an employment attorney, a contract attorney, or other lawyers might be able to discuss with you, depending on the situation and the nature of the action by the former employee. If it's just an employee bad-mouthing the company online, giving negative reviews, yeah, I think it depends a little bit on what is being said, or whether it's truthful or not, or whether it's defamatory. So I will say that there are avenues to explore, but it depends on the facts. It depends on the situation, what's being said, where it's being said, and all of those things. Great. And Jerry, to your question, working for a government entity regarding the translation of documents, it's best practice for state and public agencies to work with the centralized, so Division of Human Resources, on policies and best practices. As far as I'm aware, there's not a hard and fast legal requirement that every document be translated by a certified translator, but best practice is to have a language access plan in place. It will reduce the chance that an employee may complain of national origin discrimination, because language and accent issues are a subset of national origin discrimination. Keep in mind that public agencies are not places of public accommodation the way that a private business is. And so those are different categories, and we can talk later about that and the differences between them. So most of what I'm going to share today is directed at private businesses and the standards and expectations for private businesses. Now, in employment, there's not a distinction between public and private. So the employment laws, the expectations, and the enforcement is the same. But the forward-facing customer interactions and the public accommodation piece is different. All right, Kimberly, if an employee is in the middle of mediation on a workers' comp claim, but needs an employment action, a negative performance review, how do employers protect themselves from being accused of retaliation? That's a really good question, and one that's relevant not only to workers' compensation claims, but any type of complaint that's been made to HR, to the business owner. So anytime there's a complaint, there should be an internal investigation, and oftentimes that investigation will uncover issues with that employee or other employees that require maybe a performance improvement plan, a PIP, or some kind of counseling or some other employment action. And it's really tricky because now you have two separate issues. You have the complaint of discrimination, the workers' compensation claim, the FMLA leave request, the disability accommodation request, and now you have a need to discipline that employee for something completely unrelated. So how do you make sure that those two are uncoupled, and so that that employee is not going to say, well, I asked for an accommodation, or I had a workers' compensation claim, and now they're retaliating by disciplining me? So my recommendation for that is to separate those processes as much as possible, keep really good documentation, make it very clear in conversation, but also in writing, that we're addressing this separately. This first issue that you complained about or requested, the secondary issue is completely unrelated to that. And here's the reason why we're addressing this. It has nothing to do with your complaint. And so as much as possible, you want to separate that. Sometimes it's inevitable and you have to address employee performance and conduct in the workplace. And an employee's complaint of harassment or request for an accommodation or leave should in no way exempt them from other workplace requirements. But you just have to be very careful about how you do it and be very intentional about separating those things out. All right, the other issues that we see a lot, so sexual harassment is less than 10%. That varies from year to year. Immediately after the U2 movement really came to the fore in the national media, we saw an increase in claims about 6 months later. Then those claims dropped off a little bit in 2019, late 2018, 2019 and early 2020. And then we saw an increase in counterclaims, typically by individuals who had been accused of sexual harassment, who had been subject to an investigation, who then claimed that they were being harassed on account of their sex. So that was an interesting development. And then after about another 6 months, those tapered off and returned back to kind of average year-over-year numbers. Harassment and intimidation, about 25%. Disability claims, failure to accommodate is 34%, but over 50% of all claims have some kind of disability component. And then finally, terms and conditions of employment are about 20% of all claims that we see. I also wanted to show one area that we saw an increase in fiscal year 2022, and this is directly related to COVID. And so I wanted to spend a little bit of time, the last part of this segment where I talk about the Human Rights Commission and the work that we do, talking to you about COVID-19 and the charges of discrimination that came out of that period. Now, I know we're kind of winding down the active period of COVID-19 and the pandemic, and most of us have returned to somewhat normal conditions, whether that's returning to work for professional jobs that were able to be done remotely, or removing a lot of the masking requirements or other things like that. But I think it's important for you as businesses to know what happened in terms of complaints and legal filings during the time of COVID, and also to be prepared in the future in case we ever experience another pandemic or other similar experiences where you have to roll out certain health and safety protocols or requirements. About a year after the start of COVID, we saw a spike in charges of discrimination based on religion and disability in the workplace. Religion specifically went from an average of 5% in all of the preceding years to 22%, nearly a quarter of all charges filed with the commission in that year. And that was from July 1 to June 30th in 2021 to 2022. So a bit of a lag. It wasn't immediate. A lot of these policies took place, through the end of 2020 into 2021, and that's when we started to see the filings pick up. So there's always a little bit of a lag. So what did that look like? In terms of the nature of claims, the number one complaint that we saw related to COVID was the failure to accommodate a sincerely held religious belief due to vaccines or vaccine requirements. So an employer mandated vaccines unless there was a religious or disability related accommodation request. In some cases, that was in the form of a waiver. So you can not be vaccinated, but you have to wear a mask. In other cases, the accommodation was remote work where that was possible. So there were a variety of accommodations, but that was the number one complaint, was that the business failed to accommodate in any way a religious belief. Secondly, and related, was the disability complaint, that the businesses failed to accommodate a disability and the vaccine requirement. And related to that would be medical, non-disability medical requests for accommodation. Third, COVID-related illnesses as disability that should be accommodated. And this is interesting. So we have individuals who had long-term COVID symptoms, some for 2 to 3 weeks, that attempted to file complaints of discrimination based on a disability. Now, from our perspective at the commission, that doesn't satisfy the requirements under either state or federal law for a disability. And so those claims would be dismissed or not brought in at all. But those were regular complaints. COVID diagnoses, where we really saw complaints about a year and a half after, were long COVID symptoms. So somebody who had respiratory illness that had lasted for 6 to 12 months. And that was impacting their performance, their ability to work, and all of those things. And then finally, and this is kind of a subset, was religious accommodations or disability accommodations for COVID that segregated employees from other employees. So these were things like only vaccinated employees can be in this part of the building, or only non-vaccinated employees are allowed to eat in this part of the building, but not the others. So those types of segregation of facilities for health and safety reasons related to COVID-19. So here are some of the issues that we saw recurring in COVID-19 complaints by individuals. So the first was the failure to articulate a religious belief that is sincerely held. And it's very complicated because oftentimes individuals' religious and political or social beliefs are all intertwined and all mixed up together. And so depending on how that is expressed to the business or the agency or the organization, it may or may not be a truly religious belief. Oftentimes, employees would come and use political sound bites or things that they had read on social media. And then in the end, they would say, and because I am a fill in the blank, with their religious title or religious belief, I believe I should be exempted from the vaccine requirement. So the question that we have as we examine that in our investigation is, well, is that truly religious in nature, or is it more political or social? And that's something that businesses wrestled with as well. Now, many businesses chose to skip past that prong of the test and say, okay, we're just going to accept that, your belief as stated is religious in nature, but we're going to look at whether it's an undue burden on the business, whether we can accommodate that, or whether the health and safety issues outweigh the requirement to provide an accommodation. Other issues, failure to demonstrate a disability. So under that prong, if they were filing a disability complaint, maybe they said they have an anxiety disorder and this caused them distress, and so they were asking for an accommodation, but they'd never been treated for that. They've never been seen by a provider. And so they don't qualify under the ADA or the Human Rights Act as a qualified individual with a disability. Or finally, failure to state a claim. Accommodation as segregation, when businesses would isolate certain employees based on best practice protocols, CDC guidance, and those types of things. There's a legitimate business reason. It's following best practice guidance for health and safety reasons. And so there's not a basis for a claim for segregation in that case. Common issues on the employer side is, number one, failure to recognize sincerely held religious beliefs. So going back to that first prong, having an incredibly high bar that an employee has to satisfy before the employer will even consider an accommodation. So we saw in some cases employers that would go back 5, 6, 7 times to the employee and require them to provide written statements and letters from pastors and supporting documentation and extensive surveys. Now, while some of that is perfectly acceptable and not necessarily prohibited, even by federal agency guidance, if it becomes so prohibitive that an individual can never pass that stage, then that can be problematic. And then secondly, barring access to the interactive process, or just saying we don't make exceptions for anybody, we have no process, you can't ask for an accommodation. Even if that accommodation is leave or working from home, if absolutely they could not be interacting with patients or customers, there may not be a great accommodation for them to be in the workplace, but avoiding the process altogether is not the solution. And that was a common issue that we saw with businesses who failed to accommodate. All right, we've got another question here. If all employees are hired as at-will employees, where the employer has the right to terminate their employment at any time, with or without cause or notice, and the company has the same right, there should not be any reason for discrimination cases based on those acknowledgements. Does Idaho recognize this understanding? Yes, so Idaho is an at-will state, which means exactly what you've said, that an employer can hire and more importantly, can fire an employee for any reason at any time. But the caveat is, so long as that reason is not discriminatory or illegal under any other employment law. As long as it's not discriminatory, as long as it doesn't violate Family Medical Leave Act, as long as it doesn't violate any of the other employment laws, then any reason is fine. An employee can come to work and maybe they've got a terrible attitude and they cause a lot of dissension among their coworkers and they're just awful to work with. You can fire them on the spot for that. Maybe in a customer service forward-facing position, it's essential that they're there at 7:45 a.m. to open the doors and be ready to go at 8, and they're tardy chronically. They show up at 8:15, somebody else has to cover for them. You can fire them for that. Business downsizing, changes in your business plan, any of those reasons are perfectly fine. But if it's discriminatory, then that is prohibited under any state law and any state in the country. So while there is recognition of that, and Idaho is very clearly an at-will employment state, we still have to look out for all of those other employment laws and requirements. Now, I will also say, and I mentioned this before with the number of employees, there are some small differences between state and federal law. So like the number of employees, 5 versus 15, there are some protected categories in Idaho that are different from those categories in Washington and Oregon and California. So for instance, family status, so the presence of minor children, is protected in housing in Washington state, but not here in Idaho. Sexual orientation, gender identity are explicitly incorporated in the Human Rights Acts in Oregon and Washington, but not in Idaho. Now that gets to be a complex issue because of the way the Supreme Court has interpreted sex. And so there is coverage and protections here in Idaho as well, but it's not explicitly part of the Human Rights Act. The next question we have is about guidelines and best practices about emotional support animals. I'm going to come back to that question. That's a really good question. Service animals and emotional support animals are different. They have different applications in different places where the laws impact them. In employment, we would still talk about a reasonable accommodation, whether it's an emotional support animal, typically for psychological diagnosis, or a service animal that performs some task for that individual. And so in the employment context, what you're looking at is engaging in the interactive process to see if an animal, whether it's emotional support or service animal, is necessary to enable that person to complete the essential functions of their job. And so that's the same as it would be for any other accommodation, same process, same expectation. It's very different from a public-facing business that's required to admit service animals, and where you can only ask a couple of questions about whether that animal performs a service. So that's a different context as well. So we'll come back to that if we have time at the end, and hopefully I can answer a few more of those questions. All right, we're a little over halfway through this morning, and we're going to shift now from the Human Rights Commission, what we do, the scope of our work, and I want to focus now specifically on investigations and some tips and tricks and ways that you can improve your internal investigations and things that you can incorporate into those both before and during a charge of discrimination before the commission. Now, hopefully, if you can implement some of these things, you can avoid ever having to deal with us again through a formal charge. Now, of course, you can always interact with us through the free trainings. That's a great way to reach out to us, but hopefully you'll never have a charge of discrimination. But if and when you do, if you can follow some of these best practices, it will be much easier to go through that process. So the escalation hierarchy, and depending on your role, if you're in HR, you're probably very familiar with this. If you're a business owner or a manager, maybe a little less so. But at the very basic level, you have informal problem solving and resolution, ways that you attempt to resolve issues with employees informally, coaching, conversations, difficult conversations, those types of things. If that's not successful, or if the issue gets really bad, or you don't know about the issue and it's going on, between employees, it may escalate to an internal complaint and a formal investigation. Here's where we typically see more aggressive methods for addressing performance and conduct issues, discipline, corrective action, and so on. After that, we start to see external complaints, an OSHA health and safety complaint, complaint with us, with the Human Rights Commission, Department of Labor, and so on and so forth. If a complaint isn't resolved with those third-party external agencies, then the last step is to go to the courts. And this is an onerous process. I know from experience, the Human Rights Commission was sued a couple of years ago by an individual who wasn't happy with the outcome of a case and an investigation. We were sued in federal court. It went all the way to the Ninth Circuit. It was dismissed at both levels for lack of jurisdiction over a state agency in this context, but it's not a fun process to go through. And so I know from experience what that's like, and the time and the expense and the effort that goes into that. So obviously we want to try to resolve issues at the lowest level we possibly can. But I will say that the best practices, if you can start at that informal level of really documenting and writing things down, using some best practices, you're going to be better off as you go on to those higher levels of escalation. Now, in the case that was filed against the Human Rights Commission, I had documented interactions with the party that sued us early on in the process. And I had been very clear about our process, our role. And I not only emailed, but I emailed myself notes from the conversations that were date and time stamped. So when the party sued us and said that we never provided information A, B, and C, I was able to produce not only emails to the individual, but also my own contemporaneous notes that I had emailed and date stamped at the time. So that kind of documentation is invaluable. Now, the specific laws that are enforced, I said that I would mention, of course, the Idaho Human Rights Act. That is the statute enforced by the commission. But we also work under the corresponding federal laws, and our administrative rules and the statutes explicitly say that we construe the Human Rights Act in light of the corresponding federal statutes. So the good thing for businesses here is that you have one state agency in Idaho that actually concurrently files both state and federal charges. So you don't have to interact with both the state and federal agencies if you have a complaint, because we have a work share agreement. Any charge that's filed with the EEOC is then sent to us, to the Human Rights Commission, to process and investigate. And then they essentially certify our findings for the federal charge and federal law enforcement. So that covers Title VII of the Civil Rights Act, the ADA, the Age Discrimination and Employment Act, and also equal pay, pregnancy, and other federal anti-discrimination acts. When you get a formal charge of discrimination, and it's probably inevitable if you're a larger business, certainly, but even a small to mid-sized business, it's not uncommon. Just view the Human Rights Commission process and the response to that as the next step in the process. It's an administrative review. It's not as burdensome as going to court, although it's always advisable to seek counsel and to at least talk with an attorney about the process and your options and how to best respond. So these are the things that we look at. First and foremost are questions of facts. Question of fact. So who, what, where, when, and how, what happened, who was involved, how did things develop? And so in your documentation, this should be very well established. The facts of the case, what you did in response, how you handled the complaint, and what your internal processes are. Now, the next level of that inquiry that we do is why? Why was this done? Why was this employee disciplined? Why were they demoted? Why were they fired? And there's an important concept to know here, and this goes back to a case, a Supreme Court case, the McDonnell-Douglas case, where the court laid out the standard for the burden of proof. And the burden of proof shifts from one party back and forth. It ping-pongs back and forth between the complainant and the respondent, the plaintiff and the defendant. You as the defendant, you as the respondent in a civil rights complaint, want to be able to show very clearly with documented evidence why you did what you did. The best cases that we investigate, and by best I mean the most well-documented cases with the strongest evidence, are those that can show we fired this person for performance issues, and here are the deficiencies, and here's the documentation that shows that we counseled this person, we wrote them up, we addressed this in their annual performance review, and ultimately that resulted in termination. That's really strong evidence that's hard for an employee to overcome. Now, in other cases, an employer will say they were a terrible employee, nobody liked working with them, they had a history of poor performance, and that's why we fired them, but there's no written documentation. Any performance reviews are glowing and sound really good. And then the business might say, well, we wanted to use that as motivation. We wanted to encourage that person to perform better. And so we gave them really glowing reviews. But you can see where there's a huge gap in the evidence, and that will tend to support the complainant or the employee's allegations. So we're looking at that why and looking specifically for documentation. And then finally, we make our conclusions of law based on all of those facts in light of the relevant laws. All right, we've got another question here. We are changing our employee handbook to read, if you have a problem to report with regard to offensive actions, discrimination, sexual harassment, etc., please write a statement about the offense and bring it to your supervisor. So the question is, what is the best way for the supervisor to handle those types of situations? Would the internal investigation be held with other people in the room as witness, or does each party need to sign a statement after spoken to? That's a great question. And I would say that generally speaking, you want to have as much documentation as possible. So I think it's a great idea to ask for a written statement. Contemporaneous evidence, contemporaneous statements are the best. And so if you have a written statement, I would recommend scanning that and emailing it the same day so that you have not only the written statement, but a time and date stamp electronically. So that's a best practice. Save everything digitally in some format with a date and a timestamp, and emailing yourself is the easiest way to do that. Now, whether you investigate and interview witnesses or not depends on the facts. And so it's a very fact-specific inquiry. So I would say the more documentation, the better. The more people you talk to, the better. Especially when you have a they said situation, right? Where one party says one thing, the other party says the other. We've seen cases where a business will only investigate the witnesses on the one side, and then they'll fire the party on the other. And the party goes, wait a second, you didn't talk to any of my recommendations, my witnesses, it's not fair. And at the very least, that suggests some type of bias in the process. So as much as possible, even that out a little bit, talk to parties on both sides as much as possible and document that. I want to just briefly go over the process and what you can expect in terms of the stages. And I'll only spend a minute or two on this because I really want to get to some of the suggestions on how you can process your internal investigation. The first stage is the screening. We have over 2,500 contacts per year. Of those, we only receive about 400 filings. So we do a lot of screening early on. We refer people back to HR all the time. We refer out to other third-party agencies and organizations, depending on the nature of their complaint or concern. So if they have a workers' comp issue, we would send them to the Industrial Commission. So those types of referrals. In the filing of the charge, as I mentioned before, we're neutral. We do assist in the filing process because without that assistance, most parties would have no idea what to do or where to go or what to submit. The second, after filing a charge, the third process is service of process, and that's where we send you a copy of the legal forms and the documents that have been signed by the party. And then we begin that burden shifting analysis. The party makes a complaint. They have to minimally establish some stated connection between an adverse employment action and a protected category. If they do that, then the burden shifts to you, the business, to defend your actions and to provide evidence that it wasn't discriminatory. And then it shifts back to the employee to provide whatever evidence they can to show that no, in fact, it was discriminatory. No one else was treated the same way. I'm the only person in the protected category for age. I'm the oldest worker by 20 years, and I was the only one that was treated in this way. There was also a history of comments made about my age, about being a design dinosaur in certain industries, or being asked repeatedly for years about when I was going to retire, right? So that may be the employee's evidence. And then it may come back to the employer where you can try to rebut that with your own evidence. The mediation and the gathering of those position statements can take anywhere from 3 to 6 months, depending on how involved it is. If we have some extensions, we try to get mediation done in that whole gathering of position statements within about 3 or 4 months, but it just depends on the case. During our investigation, we evaluate questions of fact versus questions of law. If there are gaps in the facts, we may interview witnesses, we may ask for additional documentation. But if there are no facts in dispute, or if we say, for instance, that if everything complainant or the person filing says is true, but under the law, there's no possible violation because it doesn't rise to a level of an illegal violation, then we're done with our analysis and we will write that up and say, even if everything complainant alleges is true, it's not illegal under these statutes, and here's why. So that may end our inquiry. We do a lot of synthesis and analysis. We won't regurgitate all of the facts that both parties provide. Our summaries would be 20, 30 pages long if that were the case. We synthesize that and we conduct our legal analysis, and then we issue our determination. Next question, April, if an employer feels that the IHRC may need to be involved in a situation, at what point in the investigative process do you recommend the employer contacting IHRC? Great question. So now I understand your question to be about an internal investigation when an employee complains. The best thing to do at that point, if you're comfortable, is to reach out and ask for training. So if you have, let's say, an allegation of sexual harassment, you can always reach out and say, you know, it's been a while since we've done harassment training generally. We could really use that resource. Can you come out and do some general staff training? Now that's delicate because you don't want to highlight the individual who's made the complaint and then, you know, in some way kind of point them out or involve them in that. But that might be something that you can also say to that employee, okay, we recognize there are issues here. We're gonna get some third-party training to help address the current issue and prevent it from happening again. That's a really good thing to do, and it's something that we can assist with from our training standpoint. Otherwise, the other thing that you can do is you can do your internal investigation, try to resolve it to the best of your ability, document everything, follow up with the employee that's complaining. And at that point, you can also let them know that there are other avenues if they wish to file a complaint. You know, that there's pros and cons to doing that. It's not like you want to encourage employees to sue you, you know, or to file a complaint of discrimination, but it does show a good faith effort to provide that employee with all the resources at their disposal. So you may or may not want to do that. At the very least, I would say, you know, doing some training is always a good idea. All right, now let's talk best practices. We've got about 20 minutes left. I don't know that we'll use that whole time. I'll spend a little time at the end for any other questions that come up. But here are some tips and tricks that you can think about as you prepare your internal investigation and if you're responding to a legal formal charge of discrimination. So the whole point is not to just reiterate the facts, that's an important part, but it's also to make an argument to the commission or to any other third-party administrative law agency. You want to present your evidence, but argue based on that evidence what you did or didn't do. So do talk to legal, right? If you have internal general counsel, if you're a bigger organization, definitely bring them in. If you're a smaller business, I know that it's expensive to talk to an attorney, but you can even do a 1 to 2 hour consultation just to get some ideas and to orient yourself to the relevant laws and get some input early on. You know, 1 to 2 hours of consultation is not going to cost that much. Even $1,000 to $1,500 for an initial consultation and assistance is going to be way better than if you don't understand the legal framework and how to proceed, and you do end up in court, or you do end up with a lot of legal fees later on. So just think in terms of proactive instead of reactive stances to this. And do reach out to the Human Rights Commission. Back to the earlier question, you can also reach out to us and ask technical assistance questions. You know, what is typical in this situation? What are the things that a business should look out for or do with regard to an accommodation? Or you know, if we're going to fire for cause, but we haven't documented things very well, what do we do? So we don't provide legal advice. Again, we don't represent the parties, but we will provide assistance, technical assistance from our perspective in the work that we do. The other thing that we do is evaluate the credibility of the parties, especially when there are instances of he said, she said, they said, he said, you know, depending on the parties. We are going to try to establish, okay, which party is more credible here, because they're saying completely different things. There's no witnesses. There's no documented video evidence. Where do we go from here? We have to start to weigh the credibility factors. And so the more contemporaneous documentation with date and timestamps, the better. We also look at internal consistency. Does a person's story change over time? Or is there consistency in the narrative over time in those date and time-stamped documentation? And finally, this is really important. A lot of people responding to a complaint on either side will try to downplay or hide bad facts. So from a business standpoint, if you have a supervisor that really didn't know what they were doing and really bungled up how they handled an allegation of harassment, but then HR gets involved and you took it from there and resolved the complaint, but it really wasn't smooth at the beginning. That's the reality. And it's better to be upfront and forthright about that than for us to find that out later through the investigative process. It's always better to present all the facts as you know them, good and bad. And that goes to credibility, because if you're willing as a business to say, look, we messed this up here, but we fixed it, and we knew that we messed up and we addressed it and we provided remedy. You know, that person was put on leave for a month and they shouldn't have been, but we paid them their back pay. And, you know, we took care of them. We took care of the damages. That's a good resolution and something that we're going to look at when we evaluate credibility. Do follow standard best practices. When I say the IRAC format, so this is a legal standard for writing, and that means issue, rule, analysis, and conclusion. So when drafting a response to a complaint or drafting your reports, that's a really good structure to use. So, and I actually have my staff use this format in our determinations. So the issue is whether employee A harassed employee B. The rule is, the expectation is that an employee is free from harassment and discrimination in the workplace. Here's our internal policy. Here's the relevant state law. That's the rule. Now, the analysis is where you involve all of your facts and what happened and, you know, who said what and all of that. So the analysis is going to be probably the longest, and that includes both fact and your analysis. And then finally, the conclusion is your result. What did you do to resolve this? You know, do you believe there was potentially a violation? Was there harassment? And if so, what did you do about it? So if you follow that IRAC format, that's going to be easier for an agency like the commission to assess and evaluate. It's also going to reflect really well on your internal process and organization. Now, I wanted to give you some examples of what a good report looks like. So as you're drafting and preparing your reports, how do you want to prepare that down to, you know, the structure of your sentences and the way that you draft that? So here's a great example. Business responded to employee's complaint with a swift investigation and disciplined those involved in the alleged harassment. Employee did not report any further harassment. Now, there's a lot to this. If you're familiar with anti-harassment law and the legal requirements, you will know that there's liability for the business once you learn of alleged harassment. If you don't know about it, how can you be expected to do anything about it, and how can you be liable? But once you learn of that, legally, it's your responsibility to act promptly to prevent reoccurrence, to address the harassment on the one hand and prevent it from reoccurring. So in this case, we're using that legal framework to articulate what you did as the business, following that legal principle. So go back to the IRAC format. The issue is whether employee was harassed and whether the business did anything about it. Your analysis and your conclusion is, we did. We responded to the complaint. Here's what we did. And we never had any recurrence. There was never another report. So that's a really great analysis based on the legal framework. What you don't want to do necessarily, and this, if you do, it's not a big deal, but as much as possible, you want to avoid making those legal conclusions. Remember, an agency like the Human Rights Commission, we're the ones that are going to make those legal determinations. The courts will make those legal determinations. You want to present the facts and make an argument, but you don't want to go that final step and say, for instance, business did not violate the ADA when it provided employee with a reasonable accommodation. That's for us to decide, or for the courts to decide. What you can say, or what you should say, is, look, we provided employee with a reasonable accommodation. Here are the steps we went through. Here's what we did to accommodate. We did everything that we were expected to do, but you don't want to go that step further and make a conclusion of law. However, you can ask the commission for a finding. Based on these facts, business asks that the commission find no probable cause that business discriminated against employee based on her sex when it promptly acted to prevent further sexual harassment by a coworker. So that's a great example, again, going back to the legal standard and the legal expectations, where you are addressing each of the points and asking for a favorable finding. Now, again, you'll have these slides so you can kind of come back to this and revisit what this looks like. But this, again, is where it's really helpful to talk to an attorney to help orient yourself to what is the legal standard, what are the expectations. Good policies, well-drafted policies will include that, but you might need a refresher. It might be good to go to an attorney and say, okay, we've got a claim of national origin harassment. What are the different legal issues that we need to be aware of? What are our obligations? What do we need to address and do? And then they can help lay that out, just like I have here, with the specific elements that you need to address. So the takeaway from that is, don't try to do it alone. Use the format and the structure that I'm giving you here, but also consult with an attorney, consult with other experts in your field. If you're an HR professional, go to someone you trust that knows their stuff, and just discuss that with them so that you know how to proceed. All right, I already mentioned retaliation. I'm not going to spend a lot of time on this. Retaliation is tough. It's usually easier to prove than the underlying issues of discrimination. It's very natural and it's very human to want to react and retaliate when somebody files a claim or complains or does something. It's a very natural impulse to say, well, you're dragging us through the mud, you're going to a third-party agency, we're going to get rid of you. Just don't do that. It's much easier for an employee to raise an allegation of retaliation because the timing and the sequence is usually closer together. It's easier to provide that evidence than it is when there are, years of allegations or, older allegations of discrimination. So if you have questions about retaliation, reach out to me and we can chat more about that. Okay, another question. If you don't have a designated HR department, should we create that within our company or possibly outsource for when HR issues arise? Yeah, and that's a really good thing for growing companies to be thinking about. No matter your size, there should be someone designated to take complaints or to receive complaints or to address various issues, and not just anti-discrimination law, but also FMLA as you grow, if you get to that 55 threshold, at the very least for other policies. Is it the owner? Is it the co-owner? Is it the manager or supervisor? There should be some delegation of authority there, no matter how big or small the company. As the company grows, it's always a best practice to develop those policies. Outsourcing, as you mentioned, is a good idea. There are companies here in Idaho that do not only payroll and taxes and W-2s and all of that, but they will actually do HR functions as well for complaints. A lot of really big companies use third-party outsourced companies to do things like accommodation requests and leave requests. And so that in some ways reduces liability, but it also ensures a consistent format and way to manage that. A lot of times, again, for those companies that are in the growing stage where there's growing pains, there may be confusion over where to report or who to report alleged harassment to. There may be discrepancies or differences in how different complaints are handled, which can give rise to allegations of differing terms and conditions. So the more you can standardize, the more you can create a consistent policy and clear expectations of how to go through those steps, the better off you'll be. All right. When recruiting, is it okay to ignore dozens of applicants on Indeed and LinkedIn if you don't have time to send rejection messages to each individual applicant? Yeah, so I will speak from the perspective of the Human Rights Commission and best practices to avoid discrimination complaints. Again, as with internal policies, when hiring and reviewing applications, it's best to be consistent whatever you do. So if, for instance, you only respond to the top 10 or 15 applicants, you don't respond to anybody else, that's fine as long as it's consistent. And then you can stand behind that. And again, I would document your procedure and what you do when reviewing applicants. Sometimes we'll get complaints of a failure to hire where somebody says, well, okay, I'm 65 plus, so I'm clearly in the protected category for age. I wasn't given an interview. It must be because of my age. So in that case, you may have to respond to a charge. And so if you've been consistent in your process for evaluating candidates, you didn't know their age because that's not listed on the application, and you had your method of selecting candidates, that's all you have to present. But if you don't document that, that's going to be really hard to show, even though there's not a lot of evidence in support of that individual's initial claim. So the more you can document and be consistent, the better off you'll be. All right, any recommendations for HR companies that we can contact for guidance? So the same rule would apply, I would say, is you can reach out for us for input and technical assistance on the discrimination side. That's really helpful when kind of contemplating policy creation and the development of policies to know what to avoid, what not to do, and also what to do. And so again, we don't give legal advice, but I'm happy to talk with you more about best practices as you're crafting policies. And then I always recommend when creating policies to talk to an employment law attorney. Many times they will have boilerplate documents and other resources that you can draw from. They may also, for a very short period of time, 1 to 3 hours, be able to send you boilerplate documents that you can customize that may or may not be proprietary, but they can help you with that as well. What is the best way to handle applicants that disclose a protected class during the interview? Yeah, that's common as well, right? Somebody overshares, or they want to tell you all about a disability or a diagnosis, or they want to emphasize something in the interview. So one thing you can do is acknowledge and move on and just continue with the interview and, not dwell on that. The other best practice, especially with a disability or condition or something like that, is to acknowledge their statement. You can offer information about your internal process for requesting accommodations. You can say, for instance, if it were me, I wouldn't get into, oh, do you need an accommodation? What do you need at that stage until after you've made an offer of hire. And there are some particular things in terms of requesting medical information and when you can do that. But I would say, oh, we have a process for requesting accommodation. And if we get to that stage in the hiring process, if we extend an offer, then we would work with you through that process. So there are ways to kind of downplay that and not get really involved in a conversation while acknowledging and representing your company policy on accommodations and non-discrimination practices. All right. Well, in the little time we have left, I'll go back, Cynthia, to your question about guidances and best practices about emotional support animals. This is tricky in the workplace, whether it's emotional support for typically psychological or psychiatric diagnoses, or service animals, which may be for both psychiatric or psychological and physical disabilities. My best advice on that is to go through the same process that you would do for any other disability accommodation request. So where businesses and agencies and organizations often trip up is confusing the public accommodations side with the employment side. And employees will do the same. They'll come to you and they'll say, well, you have to let me bring my service animal to work because we're a service industry business, we're a grocery store or whatever, and you have to allow service animals in, and you can only ask me the 2 questions. Well, that's true for customers, but for employees, they have to go through the same process for any other accommodation, and they're not guaranteed to be able to bring their service or emotional support animal to work. And then to complicate things further, there's a third category for housing, which we won't get into, for emotional support animals. That's the most lenient. And so maybe somebody has an emotional support animal in their apartment complex, and they may be confused about what they can or can't do at work. So you can just always pull it back to your accommodation process. It's the same expectations. You can request documentation from a treating provider and go through that whole process with them. I do have one other question. The law about the animal being leashed or not in common areas of workplace when leasing from another facility, and expectations about animal bathroom breaks. So just very briefly on that, the animal, whether it's a service animal or comfort animal, is expected to be under control at all times of the owner. And so that includes bathroom breaks. It includes being on leash and under control, whether that's under the desk or next to the person. So at no time can an animal roam free. Now saying that, if the business has a policy that dogs can come into the workplace and it's not a big deal and they do roam free, that's different entirely. So you can go beyond what's required, but the minimum requirement is being under control at all times, taking care of bathroom breaks and those types of things.
Ben, thank you so much for sharing this complex information with us. You did a great job of making it very understandable for employers. Next month, or we're going every other month. So May 31st will be our next seminar, and it will be on wage and hour. So again, we will send out an email blast. If you got it today, you're on our list. You can always contact me for further information, or if you have somebody that you want to get on the list, you're always welcome to share the link. This is a free seminar. All we want to do is to educate employers. That's what we're here for at Department of Labor. So again, reach out if you have questions. We hope to see you next month, and thank you for attending.